Hello everyone, welcome back to the channel. I hope you all are doing well. In this video we will discuss about rectification of instrument. Rectification of instrument is coming under chapter 3 and it is discussed under section 31 to section 34. So first we will discuss about what is instrument. Under Stamp Act 1899 section 2 subsection 14, there it is written that instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished or recorded. So here an inclusive definition is given and it is said that instrument includes every documents, and by such documents any right or liability is created or transferred, limited, extended, extinguished or recorded. So the document by which any right or liability is created or transferred or limited, extended, extinguished or recorded, then that documents can be called instrument. So if by a document a property is sold, then a right or liability is created by that document, then that document can be considered as an instrument. So we can say that every instrument is a document, but every document is not instrument. Now we will discuss section 31. Under this section, two kinds of instrument can be rectified. First, contract in writing, then other instrument in writing. So the contract which is written can be rectified and the other instrument which is written can be rectified. There in this section it is written. So here the documents or the instrument must be written in order to get it to be rectified. Okay, a written instrument, we need to show that. Then another thing is said in this section that court may rectify a instrument under the following circumstances. First, where there is a fraud of the parties, where there is a mutual mistake of the parties, and for such fraud or mistake a contract or other instrument in writing does not truly express their intention. So if in that instrument there is a fraud of the parties or there is mutual mistake of the parties, and for such fraud or mutual mistakes such instrument does not truly express the intention of the parties, then in that situation an instrument can be rectified. So in the instrument there must be a fraud or mutual mistake, and for such fraud or mutual mistake an instrument does not truly express the intention of the parties. In that situation an instrument can be rectified. We can take an example. Here in the illustration it is written that A intending to sell B his house and one of three godowns adjacent to it. It means there A has three godowns and one of them A wants to sell to B. For that A executes a conveyance prepared by B. So the conveyance is prepared by B, in which through B's fraud all the three godowns are included. Though one godown was supposed to be included, but what B did? B included all the three godowns. Of the two godowns which was fraudulently included, B gives once to C. After getting that godown, B gives once to C and lets the other to D for a rent. Neither C nor D having any knowledge of the fraud. So the two godowns which is fraudulently included or fraudulently included and given to C or D, and C or D have no knowledge about that fraudulent inclusion of those two go downs. The conveyance may, as against B and C, be rectified so as to exclude from it go down given to C. So against C the conveyance can be rectified, but it cannot be rectified as to affect D's lease. So it cannot be rectified against D. Here it cannot be rectified against D because D has good faith and he has given a value for such lease. But C hasn't given any value, though he has good faith, because he has no knowledge of the fraud. Here A and B is making a contract, written contract, which we can see in the screen, and by that written contract A conveys a house to B and one go downs one, which was supposed to be given, that also given, and go down 2 and go down 3 is fraudulently included by B, and here the instrument was made by B, or the conveyance instrument was made by B. So now the question arises whether go down 2 or go down 3, which was fraudulently included in the instrument, can be rectified. Here the go downs 2 which is given to C can be rectified because it was given to C without any value, though C has good faith. But on the other hand, and the instrument cannot be rectified against D because D gets the go down by lease and he has given rent, so a value has been provided by D. So against D that instrument cannot be rectified. Then another point is said in section 31 is that suit for rectification of instrument can be filed by either party or his representative in interest. So either party can institute a suit for rectification of instrument, or their representative in interest can institute a suit for rectification of instrument. Then it is also said that if the court finds it's clearly proved that there has been fraud or mistake in framing in the instrument and ascertain the real intention of the parties in executing the same, the court may in its discretion rectify the instrument so as to express their intention. So here it is clearly said that court may in its discretion rectify the instrument. So court has the discretionary power in rectifying the instrument. In the using of that discretionary power, it needs to be proved that there has been fraud or mistake in framing the instrument. So court, when use discretionary power, will see whether there is a fraud or mistake in framing the instrument, and court will ascertain the real intention of the parties. So if court sees there is a fraud or mistake in framing the instrument, then court will ascertain the real intention of the parties, and court will rectify by using that discretionary power the instrument in a way that the instrument will express the intention of the parties. So court has the discretionary power regarding rectification of documents. This discretionary power can be used so far as this can be done without prejudice to right acquired by third person in good faith and for value. So we have seen the example already. There we have seen that the instrument can't be rectified against D because D does not know about that fraud or did not know about that fraud, and he has provided a value in taking the lease, or he has given the rent, so he has provided the value. So for that reason, against D, that instrument can't be rectified. This is what actually said here, that the right the rectification of instrument will be used without prejudice to right. Third party's right will not be prejudiced, and the third parties needs to show that he had good faith and he had given value. Then he is without prejudicing his right, instrument can be rectified. It is also said here. Now we will see section 32. Here it is written about presumption as to intent of parties. For the purpose of rectifying a contract in writing, the court must be satisfied that all the parties thereto intended to make an equitable and conscientious agreement. So here it is said that if court has the purpose to rectify a instrument, then court must be satisfied that all the parties have intended to make an equitable agreement and conscientious agreement. It needs to be showed, or it needs to be proved, or court needs to satisfy about it. Then court can rectify the instrument. Then we will discuss about section 33. Here it is talking about principle of rectification. Here it is written that in rectifying a written instrument, the court may inquire what the instrument was intended to mean and what were intended to be its legal consequences, and is not confined to the inquiry what the language of the instrument was intended to be. So basically here three things are said in this section. First, court will not only see the language of the instrument, court may also see or inquire what the instrument was intended to mean. So basically a language may be is saying one thing, but the instrument as a whole wants to intend to mean another thing. So court will also see what the instrument wants to mean or intended to mean. After that, court will also see, or court may see, what were intended to be its legal consequences. So what legal consequences the parties want to make or intended to make by making that instrument, court will also inquire about that. So before rectifying an instrument, court needs to follow this principle. This is written in section 33. Now we will discuss section 34. There it is written specific enforcement of rectified contract. Sometimes a rectification of instrument or a suit for rectification of instrument is filed, and plaintiff also wants to specifically enforce that rectified instrument in a proper situation. Then what will be the principle or what will be the rule is written in section 34. Here it is written that a contract in writing may be first rectified, and then if the plaintiff has so prayed in his plaint and the court thinks fit, specifically enforced. So if the contract or if the contract in writing is rectified first, then it can be specifically enforced. For that specific enforcement, plaintiff first needs to pray in his plaint about that specific enforcement. Then if the plaintiff praise it and court thinks it is a proper situation for such specific enforcement, then court can specifically enforce that rectified instrument. This is written in section 34. Now we will discuss about limitation period, or what will be the limitation period for filing a suit for rectification of an instrument. Here under Limitation Act 1908, Article 95 and 96, there it is written that 3 years will be the limitation period for the filing a suit for rectification of instrument. Here the limitation period will be counted from the date of the knowledge of fraud or mistake. From then, limitation period for rectification of instrument will be counted, and from then it will be 3 years. So it is all about rectification of instrument. I hope we have discussed each and everything written in section 31 to section 34. Thanks for watching this video.